wonder what really stops a lawyer from just doing absolutely whatever it takes to win a case, regardless of the consequences? Well, it's not just their conscience. There are rules, extremely strict ones. In this explainer, we're going to uncover the fascinating hidden rulebook that keeps legal professionals honest and, ultimately, protects your rights. The Legal Practice Council's Code of Conduct isn't just some dry bureaucracy. It's the ultimate survival guide, ensuring the entire administration of justice runs cleanly. Established under the Legal Practice Act, it is quite literally the ethical compass for the South African legal profession. It exists to maintain the profession's integrity, to protect public trust, and most importantly, it exists to protect you. We are going to map out this rulebook step by step. Who plays by the rules, the universal golden rules, marketing and specialized skills, the business of law, and finally, inside the courtroom. All right, Section 1. Who plays by the rules? Let's define our cast of legal characters. So right off the bat, you've got a core division in the legal world: attorneys versus advocates. Attorneys are the folks who practice for their own account or in law firms, manage trust accounts, and take instructions directly from the public, from you. Advocates, on the other hand, traditionally rely on a referral system from attorneys to get their instructions, though some specific trust account advocates can now take direct instructions too. But the key takeaway here is the fundamental difference in how they interact with your money and receive your instructions. But hey, what about the rookies? Don't forget candidate legal practitioners. These are aspiring attorneys serving their articles or pupil advocates undergoing practical vocational training. And here's the kicker. Even on day one, these newcomers are bound just as tightly to this exact same ethical baseline. There are absolutely no free passes for being new to the profession. Moving on to Section 2, the Universal Golden Rules. This is the absolute ethical baseline for every single practitioner. Think of these as the non-negotiable commandments of law. And what's really fascinating here is how your interests as a client are placed almost at the very top of the priority list. Practitioners must maintain the highest standards of honesty and integrity. They have to uphold the Constitution. They absolutely must put your interests first, though keep in mind that is subject to their ultimate duty to the court, which we'll get into a bit later. Add to that absolute client confidentiality, strict accounting for every single cent of your trust money, and zero tolerance for unlawful competition or underhanded tactics to poach clients. So what happens if a lawyer decides to go rogue and break these commandments? Well, that is officially classified as misconduct. If a lawyer acts dishonestly, if they charge absolutely unconscionable fees, a practice known as overreaching, or if they bring the profession into disrepute, they face severe misconduct charges. Even something like ignoring a disciplinary directive from the Legal Practice Council is a direct, punishable breach. No slaps on the wrist here. Okay, Section 3, Marketing and Specialized Skills. Let's look at how lawyers can, and definitely cannot, sell themselves. You've probably heard the term ambulance chasing before, right? Well, the code completely outlaws those kind of predatory tactics to ensure vulnerable people are never pressured into signing away their legal rights. You absolutely cannot aggressively solicit mandates. A lawyer can't, for example, go hang around hospital wards trying to snap up road accident fund claims from injured patients. Dignity in the profession is paramount. Because dignity is key, a lawyer's marketing cannot be misleading or boastful. Advertising has to be strictly factual and truthful. They can't unfairly compare their firm to another, and they literally cannot put up a massive billboard claiming they are the best in the country. The LPC demands straight facts, not hype. And you, as a client, have to pay close attention to terminology when looking at a lawyer's ads. A lawyer is perfectly allowed to say they focus or practice in family law or criminal litigation. But calling themselves a certified specialist, that is a whole different ballgame. That requires hard, formal LPC-approved qualifications and accreditations. They can't just crown themselves an expert to get your business without the formal credentials to back it up. Which brings us to Section 4, the business of law. Running a law firm has some surprising operational realities and strict boundaries. Running a firm is not like running a normal business, and that is entirely to protect you. Take fee sharing. A lawyer can share professional fees with another practicing lawyer, sure, but absolutely not with a non-lawyer. That means zero kickbacks, no paying scouts or third parties a commission to funnel legal work their way. And borrowing money? A lawyer can go to a registered financial institution, but they are strictly prohibited from borrowing money from you. You are not their personal bank. Even the physical office space is heavily regulated. To safeguard your absolute confidentiality, an attorney's office has to reflect professional independence. A law firm cannot share a reception area with a non-legal business, like an estate agent or a panel beater, if there's any risk of blurring professional lines or exposing your private client files to outsiders.
And once you actually hire them, these daily operational ethics guarantee that your lawyer executes their job with diligence. They must provide you with mandate letters detailing the exact fee structures and scope of work. They must reply to professional correspondence promptly. They've got to pay their disbursements, like advocates or sheriffs, on time. Most importantly, they can never ever neglect your file to the point where your claim legally expires or prescribes. No gathering dust allowed.
Finally, Section 5, inside the courtroom. This is where the stakes of legal practice hit their absolute peak. Let's play out a really fascinating scenario here. Imagine your lawyer is doing some deep dive research late at night and suddenly finds a binding legal precedent or legislation that completely destroys your argument. It tanks your entire case. But the opposing side? Completely clueless. They missed it entirely. So what does your lawyer do? Do they stay quiet and just win the case for you?
Actually, no. They are ethically bound to disclose that destructive precedent directly to the judge, because their ultimate duty to the court trumps everything else, even their duty to you. The absolute unbreakable rule is that a practitioner must never knowingly mislead the court. They cannot hide relevant law just to trick a judge into giving a favorable judgment.
But here's where it gets really interesting. There's a stunning contrast between hiding legal precedents and keeping factual client secrets. While a bad legal precedent must be disclosed, a private confession of guilt in a criminal trial is a totally different story. Your lawyer does not have to tell the judge that you privately confess guilt to them. That is protected by absolute confidentiality. But there is a catch. Because they can't mislead the court, if you do confess, they are forbidden from leading false evidence or fabricating a false alibi for you on the stand. The code is also incredibly hypervigilant about conflicts of interest. The second a lawyer can no longer fight solely for your side, they have to drop the case. For example, they cannot act for you if they have personal or financial interests at odds with yours, like suing a company they hold a massive financial stake in, unless they get your full documented consent. They definitely cannot represent two clients whose interests clash, like representing both a husband and wife in a contested divorce, or both a buyer and seller in a property dispute. If a conflict pops up mid-matter, they must withdraw immediately. At the end of the day, respecting the judicial system means a commitment to an effective court process. There's no playing games. Lawyers must be punctual for court appearances. They have to avoid frivolous applications or intentional stall tactics designed just to frustrate the legal process. And they must maintain total professional courtesy, treating judges, witnesses, and opposing counsel with absolute respect. So, knowing all this, knowing that this strict, uncompromising ethical compass is guiding every single move your legal rep makes, how does it change your view of the justice system? Does it make you feel a little more empowered the next time you need to hire a lawyer? Keep these hidden rules in your back pocket because understanding the boundaries of the game is hands down the best way to ensure you're getting the representation you truly deserve. Thanks for hanging out with me for this explainer, and I'll catch you next time.